In today's current microeconomic climate, layoffs may be top of mind for many individuals, particularly for foreign nationals whose status depends on their employment with the sponsoring employer. For these individuals, a layoff can mean so much more than just a loss of income. If laid off, a foreign national will need to quickly devise a plan according to their own personal circumstances and goals. And in this video, we hope to cover some of the common questions that arise from laid off foreign national employees and their employers. Broadly speaking, laid-off foreign nationals who are seeking to remain in the U.S. have the option to find new employment and file a change of employer, or file a change of status to another non-immigrant visa category, such as an F1 student, or dependent visa, or a B1, B2 visitor visa. Note that not all visa categories are transferable to a new employer. For example, the L1 intercompany transfer visa is not, and a change of status may be the only option. Under more limited circumstances, an individual may be eligible for a self-sponsored immigrant petition, such as the National Interest Waiver or Extraordinary Ability Petition, and a concurrent adjustment of status filing. In order to remain in the U.S., the change of status or change of employer must be filed during one's grace period. H-1B, H-1B1s, Es, L1, O1, and TN visa holders are entitled to a 60-day grace period after termination or until the end of their authorized period of stay, whichever is shorter. From a timing perspective, it's really important to keep in mind that some petitions may take at least a couple of weeks to be prepared, depending on the category requirements. For example, the H-1B, E3, and H-1B ones require employers to first obtain a certified labor condition application with the Department of Labor before submitting a petition with USCIS. If a change of employer or change of status petition is not timely filed during a grace period, the individual will need to depart the U.S. to avoid a violation of status and return once work authorization is secured. Similar to other visa categories mentioned earlier, F1 OPT and STEM OPT holders have a grace period of up to 60 days post-termination. F1 students who change employers must inform their DSO and receive an updated I-20. Note that the total grace period may vary for each F1 holder depending on the EAD expiry date and time spent unemployed. If the F1 student has accrued more than the allowable days of unemployment, they may not be entitled to that 60-day grace period. Avoiding international travel during the grace period is generally recommended if travel is not absolutely necessary, as travel during this time may create issues with reentry. During a visa stamp appointment or upon inspection by CBP, a foreign national may be asked to attest and present evidence of their intent to return to the U.S. to continue working with their sponsoring employer. If they are unable to do so, entry may be denied. Individuals with another visa option, such as a B1, B2 visitor visa in their passport, or an individual who qualifies for ESTA may be able to return to the U.S. as a visitor. Although, please keep in mind that re-entering in a different visa category will end your grace period time, and changing status from ESTA is generally not permissible. It's also important to keep in mind that if a visa stamp is required, several U.S. consulates around the world are experiencing extreme backlogs, and we encourage you to check the Department of State's Global Visa Wait Time page to plan accordingly. If an individual has an AOS on file, they may be able to remain in the U.S. past their visa grace period. A pending AOS allows the applicant to remain in the U.S., and the Employment Authorization Document, or the EAD, which is issued pursuant to the AOS on file, is not employer-specific. However, if the AOS is supported by an employer-sponsored I-140, the individual must find new employment to complete the process, also known as porting the application. To be eligible for portability, the application must be pending for at least 180 days, and the job offered by the new employer must be in the same or similar position to the original employer-sponsored position. If an employee on an H-1B, E3, H-1B1, and O1 is terminated before the expiration date of their status, an employer must offer to pay the reasonable cost of return transportation to their last place of foreign residence or to their home country. Further, an employer is required to notify USCIS of the termination and withdraw the underlying LCA filed with the Department of Labor in connection with the petition. Practicing empathy and providing employees with resources is the kindest gift you can provide someone during this time of uncertainty. Offering attorney consultations and hosting town halls can help distribute information and resources quickly, particularly to those in more vulnerable situations, such as those on leave of absence or traveling internationally at the time of notification. We appreciate everyone's time today. If you are an individual or a company navigating the layoff process, we encourage you to consult with an immigration attorney on next steps to discuss strategy. Thank you so much for joining.